Hello everyone, welcome back to our lecture series. And here again, today we'll be discussing the case of Sita Soren versus Union of India. We did our discussion in the first class with respect to what were the questions and what are the different provisions that have been dealt in this particular judgment. Then in the next class, we refer to the case of PV Narasimha Rao versus State 1998, wherein we discussed as to why that particular judgment was answered and laid down in a particular manner, how the law was read in that particular case. And then we come to the present judgment, wherein we see that it has been overturned, and accordingly, we see a change in the case of Sita Soren versus Union of India. So we'll be discussing the present case, and let me share my screen with you for you to recall and see that what all has been covered previously. Okay. So this is the question that we were discussing. This is the case law that we have to understand today. The facts of Sita Soren versus Union of India are quite similar, because here also we are talking about a member of the legislative body who had taken bribe, and in consequence of taking that bribe, she had voted also. But this vote, and this is where the catch is, that she had voted, she had promised while taking the bribe that she will be voting for a particular member, but she did not really do so. And rather, she voted for a member from her own party. Okay, that is JMM. So in this case, it becomes very important for us to go back to PV Narasimha Rao, wherein we saw that there was a distinction that was made in two category of people. One person who takes the bribe, and in furtherance of that bribe, the person also casts a vote as per the bribe that was so taken. On the other side, the person has taken the bribe but does not vote. If you remember from the last class, we gave the immunity under Article 105 to this person, while no immunity is given to the other person. Why no immunity? Because when we literally read Article 105 or Article 194, we recognize and we see that the protection is granted for two things, that is, for anything said in the parliament or in the house, plus for any vote that is so given in the house, right? So this is how very literally PV Narasimha Rao was construed, and we said that only immunity for this case and no immunity over here. But that is not something that we relate to, that is not something that we continue with. Okay, and where are we getting the power to read it in a different manner is Article 105 itself, that the present interpretation of these two terms in respect of anything. The judgment of Sita Soren versus Union of India, which has been decided by a bench of 7 judges, says that you have to read these texts in the light of the context. Okay. So in PV Narasimha Rao, wherein we said that a very wide import of these terms, like anything is to be done, in Sita Soren, the judges have said that you have to read the text here in context of what is so written later. And what is written later? That you will be granted immunity. No member will be held liable for any proceeding in respect of anything said or any vote given by him in the parliament or any committee thereof. Therefore, it becomes important for us to put an embargo that this immunity is only and only for these two things. And now when we read these two things, we have to see and we have to understand that this is to be read in context of test of necessity. Okay, remember, this is the test that has been so laid down in this particular judgment, that is called as test of necessity. And what is this test of necessity? It says that whatever act or omission that you are doing will be seen in the light of the duty that you have or the power that you have as the member of the legislative body. Does it have any nexus with you exercising your power? If yes, it passes the test of necessity, and for that you can be granted protection and immunity. If no, then the test of necessity tells us that no immunity shall be granted for this particular act or omission, be it an offense or not an offense. So that takes me to ask a question from you. That is, if let's say you are the member of the legislative body and you are making a speech, and in this speech you make a defamatory statement, why were you making the speech? The question comes that why was the speech being made? So you were making the speech to criticize a particular bill introduced by the member. So in that case, do you think you can seek the immunity of Article 105 and 194? Or do you think no immunity will be granted in such a situation? Drop your answer in the chat box as to what do you think, whether it passes the test of necessity or not. Okay, and this will also help you understand, when you think about it, you will understand that when the act of bribery has been done, whether it has a nexus with your duty as the member of the legislative body or not. Okay, so this is the second discussion that has been done in the judgment. First is that you have to read the text in light of the context in which it is so written. It doesn't allow, we do not allow you to give a very wide importation of the privileges that are so granted. Then we also try to understand that the privileges in India, why do we say it should not be widely construed? So the court here has answered and said that we have to identify and we have to understand the nature of these privileges. Now, what is the nature of these privileges? If you remember, I touched on this in the last class, that we do not have absolute power, right? Unlike UK, the power that has been given, or the immunity that is so mentioned in 105, is not of the same nature that exists in UK. The entire history of this power being introduced versus the nature of the present power is different, because for us we it was introduced to us by different laws, by different acts such as 1861, 1909, 1919. All this has been quoted in the judgment as well. You can find the copy of the judgment on the official website of Supreme Court as well as on LiveLaw, so you can refer to that, and you will find that these privileges in India is different, because here it has been introduced by way of a statute, that is presently the Indian Constitution, wherein it also says that Article 105 Clause 3 allows you to make or to legislate on these privileges. But is this an absolute power? No. This power will be regulated, will be reviewed by the judiciary, and they hold the power to do judicial review of the same. While it is not so as compared to the other country, that is UK, from where we took the concept or idea of immunity. And that is why it becomes very crucial for us to understand how do we read this, widely or in a narrow manner. So the judiciary has concluded that this has to be construed and this has to be read in a narrow manner, keeping in mind as to what is the idea and what is the concept of these privileges and immunity for us in the Indian jurisdiction. Okay, so I hope you will remember these 3 points from Sita Soren as to why the judgment is deviating and overturning the previous judgment. Now, the fourth question or the fourth aspect is with respect to the doctrine and with respect to the principle of stare decisis. Okay, so it was so questioned in this particular case. If I take you to the copy of the judgment, okay, this is the copy of the judgment. I referred and I introduced you to these 3 questions in the previous class that have been answered in the present case. And if we refer to the concept of stare decisis, what does it say? It says and it tells us that how the judgments have to be followed, right? And how the judgment have to be seen in future by all the subordinate courts. Now, the question here was that does it violate if we overturn the previous judgment of PV Narasimha Rao, will it violate, will it be against the fabric of stare decisis? So the court has answered it in a negative manner, and the court says that reconsidering the previous judgment does not violate the principle of stare decisis. Now, why do they say so? So, firstly, it has said that stare decisis is not a rigid principle. It is rather a flexible principle which allows that a bench of the the bench of a same strength can question the correctness of a decision that is so rendered, which has happened in this case of Sita Soren. That firstly, it was so questioned by the bench comprising of 5 judges, and later it has been corrected by the bench comprising of 7 judges. Okay, so the court has said that we have followed the doctrine, we have followed the essence of the doctrine, and accordingly we have decided this particular judgment. Okay, secondly, there are a lot of precedents also that are quoted in the case, wherein we have highlighted, wherein we have seen that how stare decisis has to be considered as a flexible rule and has to be seen in context of or in the light of development of law and advancement of justice. So when we are allowing something of this sort, the idea is to promote justice and not to restrict it in any particular manner. Okay, and the constitutional jurisprudence allows us to do the same. This is a landmark judgment which you must have studied or referred to if you have read the concept of stare decisis, or just remember that you must know this judgment with respect to the case of stare decisis, and the relevant paragraph has been so referred in the present judgment as well. Okay, so we have concluded that it is not violative of either Article 141 or the doctrine of stare decisis if in the present case we deviate from the previous judgment. In addition to the precedents, there are also certain experts that have been so quoted here. Okay, so when we read a judgment or when you become judges and you have to read a judgment, how do you interpret a particular point? If I am saying and if I am concluding that this is not violative of stare decisis, I have to assert it by referring to the law that so exists. Now, the law can be by way of what is there in the legislations, what is there in the precedents, or what is so there in the opinions of experts, right? So these are external aids. This is an example of having an external aid by which we are interpreting. Okay, so these are certain experts also who have been quoted in this particular judgment, wherein we have held, wherein we have seen that they allow us to amend the law, they allow us to amend the judgments, to change the judgment, provided it is so being done in the interest of the public. Okay, so but they also put an embargo. Now this goes further, and we understand very important part that the court has to, when they are dissenting, when the dissent is being there, you have to remember that the dissent is not lightly taken. Okay, when you are deviating from the precedent, it must be reasonable, it must be substantiated by the proper reasoning, by the proper law. Okay, so this is another important aspect by which the judgment covers and the judgment allows us to deviate from the previous judgment of 1998. Then this one particular aspect from the judgment covers the history of parliamentary privilege, the summary of which is what we have covered over here, right? So this is something that is so written here in the judgment also. They quote a lot of laws. They tell us that how these different privileges had different construction, different nature, different immunity that was granted, maybe narrower or wider immunity that was so granted in the different laws and by virtue of different laws. So we can refer to that also. And then I take you to an important part wherein we discuss about certain certain set of purports, or certain set of how do we actually see immunity, what is the functional analysis of it, why was it so included, how is it being so construed. Secondly, what is the test that is so required to say that immunity must exist or must not exist for a particular situation, in a particular situation. So this is a particular important aspect under the title F, wherein we talk about the purport of parliamentary privileges, which starts with the functional analysis of these privileges. And herein we see that how the privileges are to be exercised. Okay, so the privileges have to be exercised only when the tenure of the membership is in existence. It is only limited to the premises of the legislative body. It has certain restrictions, but not all the restrictions that are so there in 19.2. And I am again revising these things. Okay, these are things that we had covered in the first class when we were referring to these provisions. So you have to remember that what is the functional analysis, what is the idea of granting these privileges. And when we talk about a concept such as bribery, do you think that is related, or does it have any nexus with this particular act or no? So the judiciary has answered it in a negative manner, and it has said that no, there lies no nexus between the offense of bribery and with the legislative duties or legislative role that these members are exercising. So because there is no nexus, it is not necessary, and therefore it defeats the functional analysis of the immunity so granted. So this is another lens by which the judgment has has tried to substantiate as to why we are deviating and why we are changing the route of coming to a particular conclusion. All right, so these are offenses. In the previous class, we had covered all these points. We had covered the different offenses. We had covered how do we define a public servant in context of Prevention of Corruption Act. Because this has been so invoked, this has been the ground of prosecution. Therefore, we had to read public servant in context of this law. We understood it from section 2C8, and we also understood that what will be the procedure of prosecution of a public servant, that is the member of the legislative body. Okay, so these are certain things which were left in the previous class, which we have tried to cover in the present judgment. Now, when you refer to this particular copy of the case, okay, just try to read important parts from it, which I will try to cover here with you. The test of necessity, as it has been covered in this particular case, time and again they have quoted a lot of precedents such as this, wherein they are telling that this test has been in existence, this test has been used in multiple other cases as well, and it has been seen to be beneficial. And likewise, we feel that we should be importing the same test in the given case. So let's see what all judgments have been quoted here, what all precedents that have been quoted here, and try to read it and understand it in that context. So we have firstly this particular judgment of Amrinder Singh. And if you see, these are principle of necessity only. So the title says necessity test to claim and exercise a privilege. See, as when I was reading 105, I told you that the idea of granting freedom of speech in parliament is different from the idea of 19(1)(a). Correct? How is that different? I hope you remember those exceptions are not applicable over here, and therefore much more wider, comparatively wider range of right or freedom is given to a member of parliament. Then we understood it with context of why this particular idea was so introduced. And then comes this exercise of privilege. Is this exercise of privilege absolute in nature? Absolutely not, is my answer, right? So this is not absolute in nature, and therefore it has to be seen in the context of a particular test. So this to claim an exercise of privilege for whatever act you are doing, we will judge it, the judiciary will adjudicate it in context of these tests that have been laid down. And one such test is the test of necessity. Now, there are multiple judgment wherein the court says that these are the powers which depend upon and are necessary for the conduct of the business of each house. Correct? So when we are seeing it with the lens of necessity, we have to see that whatever you are doing, whether this is the power that is given to you, that is granted to you, and it is so related or it is so necessary for the conduct of the business of each house. So when you are asking a question, when you are exercising a vote versus when you are taking a bribe to exercise a vote in a particular manner, where do you think is it related to the business of the house is to be seen in the given set. Okay. Then we also see that it has been said that whether these powers are necessary to safeguard. Okay, what does it say? To safeguard the integrity of the legislative function. So there are multiple legislative functions that we have granted to you. Okay, and in context of that, are you trying to protect the integrity of the legislative function when you are taking bribe? Or is it against the idea of integrity of the legislative functions so granted to you? And therefore, the court says that these legislative functions or the privileges that are so attached to it are not an end in themselves. Article 105 and the immunity so granted is not an end in itself, and rather these are means to fulfill and means to actually perform our legislative function. So therefore it has to be seen in that manner, and you have to see whether you are actually trying to protect the essence of democracy or not. In addition to this, we also refer this judgment in with the context or with the lens of consequential analysis. So when a judgment is given, we try to see that what will be the consequence of allowing this privilege or not allowing this privilege. Will it open the floodgates of a lot of prosecution to be done against these members, or will it not reduce the immunity so granted to them by the constitution? So when judiciary decides a judgment, they can also do that, and they can also see it through the lens of the consequence that it will have. And in this case of Sita Soren, the judges have concluded that this immunity not granted for the offense of bribery is neither reducing the privilege nor extending the privilege of the members of the legislative body. And that is also how they have come up to the conclusion of overturning the previous case of Narasimha Rao. So as the other case said that bribery should be given protection if vote has been exercised in furtherance of it, the present judgment overrules and says that bribery is an offense which you have committed, which has no nexus with the legislative function that you're performing, and likewise no protection shall be granted for the same act. Okay, so these are multiple examples that you see in the judgment, wherein you see and understand that how test of necessity has been important and has stuck deep in the root of Indian context. So even though it doesn't exist in other jurisdiction, we have to see it, we have to perform, and we have to accordingly assess our immunities in context of this particular test. Okay, see, very important. The interpretation of a provision of constitution has to be seen as to whether it is violating the fabric of constitution, okay, or the essence or idea of constitution. Do you think the legislators, when they made the law, did they really intend to allow you protection for the offense of bribery? Never. And that is why these are judgments which quote and say that you do not have to allow something which is primarily and which looks against or which goes against the idea of constitution. Okay, so this is what we have covered here, this part where we were. that the interpretation of provision of constitution, it must interpret the text in the manner that it does not violate the fabric of the constitution. Okay, so you have to keep these things in mind. It is applicable not only in case of Sita Soren, but these are the rules of interpretation. These are principles that you must remember and know when you are reading any judgment. Now I'll tell you, if you are preparing for judiciary, please use these principles in your answers. If you get a problem based question, you can see, you if there is something which is going against the idea of constitution, you can't be really giving protection to it. Okay, so as a judiciary aspirant, it becomes important for you. If you are a lawyer or if you are a student of law, you are a judge, you must know these principles, because especially when I spoke about consequential analysis, when I speak about deliberative justice, these are principles that you must understand and know as a lawyer or as a student of law. Okay, all right, then we have already covered that how in respect of and anything is to be read. Okay, so we do not allow it to be, granted a liberal interpretation. Rather, we say that it has to be understood in the context of what is written in that particular provision. And here in this case under 105, it very clearly says that why did we use the term speech and vote? Because we wanted to grant you immunity for these set of privileges only, or these set of functions only. Okay, then we go to the conclusion of the judgment and try to revise our class from last 3 days. Whatever we have studied, this is the time wherein you go and see from the conclusion whether you have understood everything or not. Okay, so one is, we understood that there will be no immunity for the offense of bribery. Correct? This is the first important part that you understood. Then we understood that the right to vote has to be exercised in a bona fide manner, and the privileges that are so granted is for the functions given to you or delegated to you as the member of the legislative body. Okay, so something that you're doing, criminal conspiracy that you have done in this case, is not something that will be, given protection or given immunity in the present context of fact. And Article 1052 allows immunity only and only for the restrictive nature, for the privileges that you have to work on, and the right to vote is an independent act from the right of taking bribery. So I can say that right to vote is independent of right to take bribery or the action of bribery. Okay, now we can't say right to bribery, we will say act of bribery. Clear? So I hope this summary will be important and will be of use to you. You can also write in your notes is the first point, second point, third point, and the fourth point. This is how you can conclude your answer and reading of Sita Soren versus Union of India. Now from the judgment, I will quickly take you through for you to understand that we have covered all these points. Okay, so let's say the doctrine of stare decisis is not an inflexible rule. We understood, because this was a question in Sita Soren versus Union of India as to whether, we will be violating the doctrine of stare decisis if we overrule and overturn the previous judgment. The court said that it is not so. It is not an inflexible rule, and we can accordingly do so. We understood that the judges have said here, the bench with 7 judges have said that we disagree and we overrule the previous judgment of P.V. Narasimha Rao. Okay, we understood that the House of Commons in UK, the privileges granted over there is different from the privileges granted to us here, and this is also covered. We also understand that these privileges are amenable to judicial review, and accordingly we can it can be reviewed, whatever privileges you're granting and allowing to the member. Then the individual members as well as the house collectively have immunity from granted under Article 105 and 194, which we have understood. But it is important that you must prove it to the court that whatever you have done is necessary for discharge of essential duties of you as a legislator. Then we say that Article 105 and 194 is important because we have to promote debate and deliberation in the houses of parliament, right? In the House of Parliament as well as state legislature. So we are promoting debate and deliberation. This is also something that we have covered. We have understood that how we are supposed to read these expressions. These have to be read in context of the accompanying expression, accompanying words that are so used in the provision. Okay. And then we have understood that bribery is not rendered immune in this particular provision. It is something which is not related to your right of casting the vote. Corruption and bribery by the members erode the probity in the public life. So we would be going against the essence of constitution and democracy if we allow the members to take the shield of these immunities and accordingly commit the act of corruption and bribery. There is, as I spoke about consequential analysis, there is a potential of misuse. Okay, if we allow something of this sort, there will be a lot of misuse that can be done, and accordingly we realize that such protection not granted for offense of bribery will neither enhance nor diminishes any of the jurisdiction of the court to prosecute these members. So these are all the points that we see in the judgment, and accordingly we conclude and we summarize that this particular case of Sita Soren versus Union of India, in which the jurisdiction of the Honorable Supreme Court was invoked, how? By the criminal appellate jurisdiction, right? It has overturned the previous judgment with respect to the question of immunity that is to be granted to the members of the legislative body. But at the same time, we also conclude and understand that the question of them being the public servant has not so been challenged in the given case, and we continue with the same understanding of PV Narasimha Rao that we had done before. Okay, so I am concluding this class now. I'm concluding this case law. In the 3 lectures that we have taken so far, we've understood one particular judgment. I hope this was beneficial for you. I hope you feel that you've understood one reading of this particular judgment, idea of this particular judgment. You've also understood why protection is important, why why these privileges are so granted. You can use this particular case law in understanding the privileges in concept of in concept like defamation, in concept like parliamentary privileges. There also you can again revisit this judgment and use this judgment to understand that concept better. And in addition to this, I would just urge you to leave a comment if you have any doubt. I would be more than happy to revisit and to see your doubts and to answer them. And if you have any request with respect to any case law that we must cover, 7 judges bench, 9 judges bench, there are a lot of landmark cases that have been, covered in 2024. We will be discussing some of them. But if you want any particular judgment to be dealt by us in this thorough manner, please feel free to leave a comment in the comment box, and I would be more than happy to teach you and cover that same in our lecture series. Thank you so much, all of you. I hope you all get benefited, and I hope you all enjoy this lecture series. Thank you so much.